The Subcommittee on Commerce, Manufacturing, and Trade will now come to order. The Chair recognizes himself for 5 minutes for the purposes of an opening statement. And I certainly want to welcome everyone on our panel to the hearing to provide an update on patent demand letters, the practices, and possible solutions. Unfortunately, abusive patent demand letters are not a new problem, and they are not new to this subcommittee. Patent trolls continue to send demand letters in bulk to include victims to pay unjustified license fees rather than fight back. Last year, under Subcommittee Chairman Terry, this subcommittee held an oversight hearing, a legislative hearing, and eventually produced and marked up draft legislation targeting bad faith demand letters. As this subcommittee learned through its process, the act of defining a so-called troll is a difficult task. In protecting companies from trolls, legislation must also not prevent legitimate patent holders from protecting their rights from being infringed upon by other actors. But a task that is difficult is not a task that is impossible. And I have a sincere belief that in the realm of patent demand letters, like so many other areas under the jurisdiction of this subcommittee, we can effect a bipartisan agreement and legislation. So here we are in a new year and a new Congress, and we renew the effort to forge ahead to achieve this goal. We again take aim to solve a small piece of the patent world that has caused some of the greatest consternation. I sincerely believe that a targeted solution to this problem is the best one, and I hope that our hearing today will restart the conversations on how best to stop this activity, yet allow legitimate patent holders to proceed. The truth is that the destructive business model of the so-called patent troll has largely skated just beyond the reach of the law, and as a result, crime pays. And because federal law has been slow to keep up with the evolving world of patent trolls, even in a subject area where federal jurisdiction is clearly delineated in the Constitution's Article 1 enumerated powers of Congress, the states now have felt an obligation to begin looking at ways to protect their constituent companies. Protection of intellectual property rights is a federal issue. Indeed, Article 1, Section 8, Clause 8 clearly envisions Congress as having both the power and the duty to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. It would appear from these stories that we have all heard about patent trolls that the protection of these rights is not being considered. This committee wishes to change that equation. I'm especially concerned about the effects these fraud schemes have on small businesses. When a business receives a demand letter, especially one that is intentionally vague or misleading, many small business owners simply lack the tools necessary to distinguish a bogus assertion from a legitimate infringement claim. However, the United States Patent Office lists 3 websites: Stand Up to the Demand, That Patent Tool, and Trolling Effects as resources that companies can use to protect themselves. There is work going on beyond this subcommittee to address some of these issues. For example, a number of websites have popped up for demand letter recipients to verify the legitimacy of infringement claims against them. 18 states have also enacted legislation, and a handful of state attorneys general have brought cases under their consumer protection laws. As we will discuss today, it may be that state efforts to curb patent abuses are on uncertain legal footing due to the preemption of the First Amendment doctrines that were developed by the federal courts. These doctrines are designed to protect the fair assertion of patent rights, and any legislation this subcommittee produces must allow legitimate assertions. It is my intention that this committee can work with companies who own large patent holdings to address this issue. As many companies have seen, illegitimate claims could ultimately undercut the value of legitimate patents. To help us strike the proper balance, we will hear from experts in the field as well as representatives from both abusive demand letter victims and a large patent holder. We hope this will inform the direction of whatever legislation this subcommittee ultimately produces. I hope that we may use last year's draft, the Targeting Rogue and Opaque Letters Act, as a place to begin the discussion. One area where we will need to focus is how the bad faith standard in that legislation would work with the required disclosures in the Act. Further, how those required disclosures fit with the prohibited bad acts included in the draft legislation, and I hope that's an area we can examine closely. The subcommittee is eager to work with the panelists before us and to address this problem. I thank the witnesses for their testimonies, and I certainly look forward to the discussion today. And the chair now recognizes the subcommittee ranking member, Ms. Schakowsky of Illinois, for 5 minutes for the purpose of an opening statement.
Thank you, Mr. Chairman, and much of what I will say will echo the things that you have said, along the lines of the problems with patent trolls. I see the rise of these entities as a serious threat to consumers and businesses all across the country, and I want to explore whether we can strengthen existing protections against them as well. Patent assertion entities typically purchase patents and then assert that those patents have been infringed, sending vague and threatening letters to hundreds or even thousands of end users. Typically small businesses or entrepreneurs. Those businesses are told that they can pay the patent troll to continue using the technology. And considering the cost and resources needed to vet and fight a patent infringement claim, although the chairman did point out some resources that are available, many small businesses do choose to settle the claim by paying the troll. Others investigate and fight the claims, draining precious resources and stunting the growth of their businesses. It costs patent trolls virtually nothing to send patent demand letters, but they have cost American businesses tens of billions of dollars in recent years. At best, patent trolls are misleading, and at worst, they are extortionists. This is fundamentally a fairness issue. As the subcommittee charged with protecting consumers and promoting fair business practices, we must work to reduce frivolous patent claims. I'm glad that the FTC is using its existing authority to order injunctions on patent assertion entities that are determined to engage in unfair, deceptive acts or practices. I believe that if we legislate on this issue, we should include new authority for the FTC to collect civil penalties for those abuses. While we should also make sure that important consumer and business protections that are guaranteed and enforced at the state level, including Illinois, remain in place. Federal legislation could also ensure that transparency and baseline standards are required for patent demand letters. There are many ideas about how to increase transparency, including proposals to require information in patent demand letters about the patent alleged infringement, the patent that's allegedly infringed, and the technology used that allegedly infringes on the patent. As we consider acting on this issue, we must also recognize that many patent infringement claims are reasonable efforts, as the chairman mentioned, reasonable efforts to protect intellectual property. We also need to be careful to make sure that universities, research institutions, and others that develop and hold patents but may not develop products for sale are not unfairly labeled as patent trolls. We should not undermine the ability of innovators to develop and defend their patents. I look forward to hearing the ideas of the panel about how we could move forward with legislation and how it should be structured to make sure that patent demand letters are more fair and transparent moving forward. And I thank you again, Mr. Chairman, for holding this hearing. I yield back.
The gentlelady yields back. This is the point where the chair would normally recognize the chair of the full committee, but seeing, and I do want to explain to our witnesses, there is a concurrent hearing, subcommittee hearing downstairs, and we may well see members come in and out today, and it's not a sign of disrespect. It's a sign of there's just a lot of work to be done this morning. Mr. Mullen, would you seek time for an opening statement? Gentleman does not seek time. Chair recognizes the ranking member of the full committee, Mr. Pallone, for purposes of an opening statement, 5 minutes.
Thank you, Mr. Chairman. The patent system plays a crucial role in promoting innovation. It provides an incentive to inventors to make costly and time-consuming investments in research and development of new inventions. At the same time, the system requires that the inventions be disclosed so that others can build upon the inventions. Unfortunately, there are a number of problems with the patent system, and reforms are needed. I've long pushed to reduce the backlog of patent applications at the Patent and Trade Office, but we also need to work to address the concern that some applications are being approved for inventions that are not truly new or non-obvious. In addition, the patent litigation system must be streamlined. While most patent-related issues are in the purview of the Judiciary Committee, and I look forward to its action on patent system reform, the Energy and Commerce Committee is responsible for efforts to curb fraud. And one part of the patent litigation area in need of attention is the rise of so-called patent trolls and the sometimes fraudulent demand letters they send to small businesses. This trolling activity is a problem. Patent trolls do not invent, make, or sell anything. Instead, they buy up large numbers of patents, often of suspect validity, and then send demand letters or bring lawsuits using the complexity of the patent system and the high cost of litigation as leverage to force licensing fees or settlements. It's not fair to the targets of these predatory tactics, nor does it serve the interests of true innovators. And efforts to combat abusive demand letters have already begun. Some state attorney generals have taken legal action to protect their citizens from unfair and deceptive demand letters. In addition, 18 states have already enacted legislation to tackle this abusive activity. Furthermore, the FTC brought an administrative complaint against MPHJ Technologies, a well-known patent troll. That case was recently settled through a consent order that prohibits MPHJ from making deceptive statements in its demand letters. Last Congress, this committee held 3 hearings, and the subcommittee marked up a bill which I believed included problematic language. Among other things, it created a knowledge standard, one not typically needed to prove fraud, and it preempted stronger state laws. I'm happy that this issue is being given a fresh review this Congress in an effort to get the language right and work in a bipartisan fashion. If we as a Congress choose to legislate in this area, we need to make sure that we're furthering the interests of the consumer, end users, and small businesses while protecting the vitality of the patent system. So today's hearing presents an opportunity to hear from witnesses about how big is the problem of fraudulent demand letters and whether there is an appropriate legislative fix. And I look forward to hearing the witnesses' thoughts on this issue and their ideas for possible solutions. I yield back.
The gentleman yields back. This concludes opening statements. We want to welcome all of our witnesses and thank you for agreeing to testify before the subcommittee today. Our witness panel for today's hearing will include Ms. Lori Self, the Vice President and Counsel of Government Relations, will be testifying on behalf of Qualcomm. Mr. Vince Malta, Liaison for Law Policy at the National Association of Realtors. Mr. Paul Gugliazza, close enough, Associate Professor at Boston University School of Law, and Ms. Vera Ranieri, Staff Attorney for the Electronic Frontier Foundation. We welcome you all to the committee, and Ms. Self, we'll start with you. You're recognized 5 minutes for the purposes of an opening statement.
Thank you. Chairman Burgess, Ranking Member Schakowsky, and members of the subcommittee, thank you for the opportunity to appear today to discuss patent demand letters. My name is Laurie Self, and I am Vice President and Counsel, Government Affairs for Qualcomm. Qualcomm is a member of the Innovation Alliance, a coalition of research and development-focused companies that believe in the critical importance of maintaining a strong patent system. Qualcomm is a major innovator in the wireless communications industry and the world's leading supplier of chipsets that enable 3G and 4G smartphones, tablets, and other devices. Qualcomm's founders are the quintessential example of American inventors in the garage who built one of the world's foremost technology companies. Today, the technologies invented by our engineers help make nearly everything you do with your smartphone, from browsing the internet to sharing videos to using GPS navigation. We are an invention hub for the mobile age, having spent more than $34 billion on R&D since the company was founded in 1985. Through the broad licensing of our patented technologies, Qualcomm has helped foster a thriving mobile industry that accounts for more than 1 million jobs and $548 billion of U.S. gross domestic product. Qualcomm itself has more than 31,000 employees, the vast majority of whom are engineers based in the United States. It's worth noting that Qualcomm is not a plaintiff in any pending patent litigation, but we are a defendant in several patent infringement lawsuits, some of which were brought by so-called patent assertion entities. However, I am not here to criticize or defend PAEs, but instead to address what we believe should be the proper focus of any patent demand letter legislation, namely targeting abusive demand letter activities without unintentionally damaging important patent rights. Notice letters play an important role in the patent system for both patent holders and accused infringers. Patent law encourages and sometimes requires patent holders to take reasonable steps to notify others of possible infringement. Meaningful patent protection, including the ability to provide notice, is a key factor for companies like Qualcomm in deciding whether to invest in new products and technologies. Qualcomm appreciates the committee's interest in curtailing abusive demand letter activities. At the same time, we urge the committee to be cautious so as not to inadvertently hinder legitimate patent enforcement practices. A demand letter law that makes patent notification or enforcement too burdensome, too costly, or too risky may deter appropriate notice activity. If valid patent owners are afraid to seek compensation for use of their inventions, the whole patent-based system of incentivizing innovation is undermined. Qualcomm supports the demand letter bill that passed this committee in July 2014, the Targeting Rogue and Opaque Letters Act. The Troll Act includes several key features that are necessary to strike the appropriate balance. First, the bill clarifies rather than expands the FTC's existing authority under Section 5 to address abusive demand letters. Second, the bill is limited to situations in which the sender has engaged in a pattern or practice of mailing bad faith demand letters to consumers. The pattern or practice requirement appropriately targets the mass mailing of deceptive demand letters, and it's consistent with the FTC's Section 5 authority. An explicit bad faith requirement is necessary to protect patent holders' constitutional rights. Patent property rights are rooted in Article 1 of the Constitution, and the First Amendment provides strong protections for patent demand letters. As courts across the country have recognized, pre-lawsuit communications implicate both the freedom of speech and the constitutional right to petition the government. To conform with the Constitution, legislation must avoid punishing patent holders for good faith conduct. By clarifying the FTC's enforcement authority under Section 5, the bill is limited to communications sent to consumers, including mom-and-pop retailers, which protects those most vulnerable to abusive demand letters, while reducing the risk that the FTC will be drawn into business-to-business disputes. Third, the bill clearly describes the conduct that would be considered unfair and deceptive and does not impose overly burdensome disclosure requirements. Fourth, the bill preempts state demand letter laws but allows state attorneys general to bring enforcement actions under the federal statute. With nearly 20 state legislatures having passed such bills over the past 2 years and another dozen considering such a bill now, it would be extremely burdensome to subject patent owners to a patchwork of different demand letter requirements in every state. Preemption is appropriate and necessary in the demand letter context because, unlike the Troll Act, many of these state demand letter laws are overly broad in scope, highly burdensome to patent owners, and risk penalizing ordinary commercial and pre-litigation communications, which are protected under the First Amendment. These 4 features are critical to Qualcomm's support, and we urge the committee to retain these requirements and limitations in the bill. Qualcomm looks forward to working with the committee in its efforts to achieve a balanced and narrowly tailored bill. Thank you for allowing me to testify today, and I look forward to answering your questions.
Gentlelady yields back. Thank you for your testimony. Chair recognizes Mr. Malta. 5 minutes for the purpose of an opening statement, please.
Chairman Burgess, Ranking Member Schakowsky, and members of the subcommittee, my name is Vincent Malta. I'm the broker of record for Malta & Company in San Francisco, California. I serve as the 2015 National Association of Realtors Liaison for Law and Policy, and I'm here to testify on behalf of the 1 million members of NAR. I'm also here representing the United for Patent Reform Coalition, a broad and diverse group of Main Street, high-tech, and manufacturing companies that have united to urge the passing of strong, common-sense patent reform. In the real estate industry, patent trolls have targeted realtor brokers, agents, and multiple listing services for implementing simple website technologies. Here are 5 examples where patent trolls have alleged infringement. First, the Real Estate Alliance Limited filed an infringement lawsuit against a broker and other unnamed defendants, charging that zooming in to locate points on a map was an infringement. The case was eventually dropped after 2 years. Second, a company called Civics DDI LLC charged that providing a searchable database of property listings infringes its patents. Civics had targeted not only multiple listing services in the real estate industry, but Microsoft, Expedia, Move, and other companies. NAR decided to settle this case for $7.5 million, fearing that the cost of letting the case go to trial would be exponentially more expensive. Third, Data Distribution Technologies charged that a number of real estate firms were in patent violation by providing updates to consumers when properties matched their search criteria coming on the market. This patent is undeniably abstract because it describes what any real estate professional already does. The real estate companies had to expend time and money to challenge the validity of this abstract patent, finally settling after 2 years. The Austin Board of Realtors received a demand letter alleging patent infringement for having a drop-down menu on their website. And finally, NAR members received abusive demand letters from the MPHJ Technologies troll that notoriously sent over 16,000 demand letters to businesses demanding payment for using basic scan-to-mail technology. Simply put, these patent trolls make everyday business practices potential lawsuits. Patent trolls typically start by sending form demand letters to dozens, hundreds, or even thousands of businesses at a time. They claim these businesses are infringing on patents but provide little to no evidence. Typically, the sender will list a patent number only, with no reference to which claim within the patent is alleged to have been infringed. The letters are often intentionally vague and demand a licensing fee or threaten litigation. If the business does speak with a lawyer, they're often advised to pay the fee rather than risk very costly infringement lawsuits. This essentially is a junk mail approach that is clogging up our legal system. NAR members and other small businesses rightfully feel extorted by this process. In 2013, more than 2,600 companies were sued by patent trolls, representing 60% of all patent infringement cases brought that year. Small and medium-sized companies paid on average $1.25 million to settle patent troll cases and $1.7 million on average in court defense costs for patent troll litigation. Economists estimate that in 2011, patent trolls cost operating companies $80 billion in direct and indirect costs. That is more than the $66 billion state budget of Illinois, and in 2013 almost reaches the $96 billion state budget in Texas. This is a serious problem for the American business community, in particular small businesses who lack the resources to fight these pointless battles. NAR's most recent surveys indicate that more than half of all realty firms have less than 25 agents. In the last Congress, this subcommittee passed legislation aimed at addressing demand letter abuse. NAR and the Coalition appreciate the subcommittee's work on the Targeting Rogue and Opaque Letters Act. As the subcommittee considers legislation in this Congress, we ask that you consider a few essential guidelines. Fundamentally, patent demand letters must be held to a practical standard of transparency. They must specify the relevant patent claim at issue. They must detail how a business is allegedly infringed. They must include a description of the patent troll's investigation of the alleged infringing activity, and they must disclose the real parties and interests to the dispute. This minimum information will help recipients to thoughtfully review whether infringement allegations merit an agreement to license. In conclusion, NAR and the United for Patent Reform Coalition urge Congress to act swiftly to enact meaningful demand letter reform for the good of our nation's small business community. And while demand letter reform is crucial as an important first step toward broader patent reform, it requires comprehensive and multifaceted reforms. Thank you for your consideration of our views.
Gentleman yields back. Chair thanks the gentleman for his testimony. Professor Guglielza, you're now recognized for 5 minutes for the purpose of an opening statement.
Chairman Burgess, Ranking Member Schakowsky, and members of the subcommittee, thank you for inviting me to testify. My name is Paul Guglielza, and I am an associate professor of law at Boston University School of Law. My research focuses on patent law and patent litigation. Most relevant to this hearing, I've spent the past 2 years studying the issue of patent demand letters, focusing in particular on efforts by both state governments and the federal government to address the problem of unfair and deceptive conduct in patent enforcement. To briefly summarize my conclusions, a small number of patent holders, often called bottom feeder patent trolls, have been abusing the patent system. These patent holders blanket the country with thousands of letters demanding that the recipients purchase a license for a few $1,000s or else face an infringement suit. The letters are usually sent to small businesses, nonprofits that do not have the resources to defend against claims of patent infringement. And the letters often contain false or misleading statements, calculated to scare the recipient into purchasing a license without investigating the merits of the allegations. In response to this troubling behavior, legislatures in 18 states have adopted statutes that, generally speaking, outlaw bad faith assertions of patent infringement. These statutes, however, may be unconstitutional. The U.S. Court of Appeals for the Federal Circuit, which hears all appeals in patent cases nationwide, has held that patent holders are immune from civil claims challenging their acts of enforcement unless the patent holder knew that its infringement allegations were objectively baseless. This rule could provide patent holders with nearly absolute immunity from liability under the new statutes. In fact, the rules already immunize two notorious trolls, Innovatio IP Ventures and MPHJ Technology Investments, from legal challenges to their enforcement campaigns under state consumer protection laws. Although the Federal Circuit has sometimes called this immunity rule a matter of the Federal Patent Act's preemption of state law, this rule could also limit the ability of the federal government to regulate patent enforcement behavior. This is because the Federal Circuit's decisions are not grounded in the Constitution's Supremacy Clause, which is the usual source of preemption doctrine, but in the First Amendment right to petition the government. Unlike the Supremacy Clause, the First Amendment limits the power of the federal government, not just state governments. Accordingly, patent holders may also be able to invoke this immunity to thwart federal initiatives to fight patent trolls, including any legislation this committee might consider. To be clear, no court has yet addressed the constitutionality of the new state statutes. Moreover, as I discuss in more detail in my written statement, there's a strong argument that the Federal Circuit's immunity doctrine is wrong as a matter of law, policy, and historical practice. So it's entirely possible that the Federal Circuit could revise its immunity doctrine to accommodate greater regulation of patent enforcement conduct. Indeed, the Federal Circuit keeps close watch when Congress is considering amending patent law, and in the past decade, the Court has repeatedly revised its case law to align with proposed legislation. This hearing provides a welcome occasion to discuss the innovative steps that state governments have taken to combat unfair and deceptive patent enforcement. Any bill advanced by this committee should, in my view, capitalize on the respective strengths of state governments and the federal government in this area. The strengths of state governments include, first, the quantity of law enforcement resources that could be provided by dozens of states' attorneys' general offices cooperating to fight abusive patent enforcement. And second, the accessibility of state governments to the small businesses, nonprofits, and local governments most likely to be targeted by deceptive campaigns of patent enforcement. By contrast, federal legislation on patent demand letters would provide the benefits of legal uniformity and predictability for patent holders about whether or not their enforcement actions are legal. In addition, as I explained in my written testimony, federal legislation could clarify difficult jurisdictional issues that currently arise in cases challenging the lawfulness of patent enforcement conduct. If this committee determines that federal legislation is warranted, that legislation should, in my view, specifically condemn bad faith assertions of patent infringement. Until the Federal Circuit adopted its objective baselessness requirement, courts had applied a bad faith standard for nearly a century, striking an appropriate balance between the goals of punishing extortionate schemes of patent enforcement and respecting patent holders' rights to make legitimate allegations of infringement. Thank you again for inviting me to testify, and I'd be pleased to answer any questions the committee might have for me.
Gentleman yields back. The chair thanks the gentleman for his testimony. Ms. Ranieri, you're recognized for 5 minutes for the purpose of an opening statement.
Mr. Chairman, Ranking Member Schakowsky, and members of the subcommittee, thank you for the opportunity to be here today. For those of you who aren't familiar with my organization, the Electronic Frontier Foundation, or EFF, we are a nonprofit organization dedicated to protecting consumer interests, innovation, and free expression in the digital world. As part of that work, we regularly advocate for reform of the patent system in courts, Congress, and at the Patent and Trademark Office. EFF is greatly encouraged by Congress's interest in the important issue of deceptive and abusive patent troll demand letters and its impact on consumers and small businesses. EFF is one of the few nonprofit legal services organizations that small businesses and innovators can turn to in order to get help when faced with a patent troll demand letter. Unfortunately, we cannot help everyone, and more importantly, because of a lack of meaningful, manageable legal options, we're too often unable to help push back against those who use deceptive patent demand letters in order to extract money from their victims. The problem of abusive patent troll demand letters is a result of a perfect storm of circumstances. Patent owners sending these letters use vague and overbroad patents that likely never should have issued in order to confuse and obfuscate. Patent owners rely on the eye-popping cost of litigation in order to intimidate, and patent owners take advantage of their victims' relative lack of experience with technology and the legal system to ensure improper claims of infringement go unchallenged. For example, in 2011, a company known as Eclipse IP sent demand letters to various retailers alleging infringement of patents on tracking packages through the use of UPS tracking. Eclipse demanded licenses in the hundreds of thousands of dollars. Seeing their customers being targeted, UPS filed a declaratory judgment of non-infringement and invalidity. But before the court could address whether Eclipse's claims of infringement had merit, Eclipse filed what's known as a covenant not to sue. In doing so, Eclipse ensured that its patent rights would not actually be litigated. That is, they did everything in their power to stop the court from deciding the merits of its claims. Eclipse apparently merely wanted to extract settlements from its victims, despite assertions in its demand letter that it would engage in litigation if its licensing demands were not met. Since 2011, Eclipse has sued over 100 companies and presumably sent letters to countless others. Letters and actions like Eclipse's are all too common. Other letters employ tactics such as not mentioning licenses that likely exhaust patent rights, or use complex and vague nonsense terms from the patent in order to make infringement claims that would never have been apparent to someone reading the patent. Dealing with even the most frivolous of letters takes time and money away from what small businesses should be doing, which is growing their business and creating jobs. I could tell many more stories, but most demand letters never see the light of day. Recipients of letters from patent trolls are often afraid of speaking out, and no wonder. By speaking out, they worry they become an even bigger target and subject to even larger demands they cannot afford. Patent trolls use this fact to hide their practices from scrutiny and from lawmakers and the public. Deceptive and unfair patent troll demand letters must be addressed, but it is important to address them in a way that makes sense. Specifically, Congress should not limit the ability of state attorneys general to protect their citizens, whether that be through state laws addressing abusive demand letters or through their own little FTC acts. State AGs are often the closest to the problem and in the best position to address deceptive practices targeted at their citizens. Second, Congress should allow for flexibility in the law. Overly rigid rules regarding what constitutes bad faith will allow patent trolls to comply with the letter of the law, but not the spirit. As a lawyer, I can assure you that we are enterprising people. If there is a loophole to be found, we will find it. Flexibility is key to ensuring patent trolls don't find new ways to deceive their targets. Finally, in order to protect technology end users such as retailers implementing tracking technology or the coffee shop offering Wi-Fi, Congress should mandate disclosure requirements. Through these disclosure requirements, Congress can better understand the scope of the problem, and agencies such as the PTO, the FTC, and nonprofit organizations such as EFF can better target those practices and those patents that are being abused. Addressing the deceptive patent troll demand letter problem is an important piece of broader patent reform. In tandem with other measures, we can limit the ability of patent holders to use patents that never should have been issued to extort undeserved money from those who just want to pursue their livelihoods. Thank you, and I look forward to your questions.
Gentlelady yields back. Chair thanks the gentlelady and all the witnesses for their testimony this morning. Very informative, very helpful. Professor, I'm now reminded why I didn't go to law school. But complex discussion, and certainly the issues you bring before us are of importance. Chair now moves to the questioning part of the hearing. I'm going to recognize myself 5 minutes for questions. Also, just an observation, when this issue came up in the previous Congress, when Chairman Terry was in charge of the subcommittee, I think it actually came to before the Rules Committee, and we had a member who appeared before the Rules Committee and said he was conflicted because some days he was asserting he was a patent troll, the other days he was not, and defending a patent. So it did underscore for me how there can be actually people on both sides of the issue. But let me just ask this question to start off for the entire panel. I would like to get everyone's thoughts on this. Myself, we'll start with you and then move down the panel. How has the concept of bad faith been applied in patent law, and how should it apply to the demand letter context?
I think the concept of bad faith is critical in the patent demand letter context because it prevents the use of antitrust or Section 5 enforcement authority in a manner that would violate the patent owner's constitutional rights. And as has been said, those rights include First Amendment rights of free speech, rights to petition, but also the right to communicate about your patent is fundamental to your ability to enforce your patent. If you think about how patent owners sort of alert the world to the fact that they have a patented invention, and this has been true from the first days of our patent system. You make a public disclosure of the patent application as kind of a quid pro quo, if you will, for the right to enforce your patent, but your ability to enforce your patent is dependent on communication. If you're stifled in your ability to communicate about your patent, to make good faith communications about your patent, then effectively your patent's not enforceable. So bad faith is really critical to delineate the kind of conduct that would be appropriate for FTC enforcement. And I think it's also important to send a signal to state enforcement authorities that legitimate patent demand correspondence should not be the subject of state enforcement activity or federal enforcement activity. So bad faith is really the cornerstone, if you will, in our ability to strike that right balance between protecting the interests of recipients who may be receiving these deceptive communications, but also supporting the vast majority of legitimate communications that are really fundamental to our innovation economy.
I might come back to you because you brought up the issue of pattern of practice, but I want to go down the panel for just a moment. Mr. Malta, the concept of bad faith.
Chairman Burgess, I'm a realtor, and my members sell the American dreams, and entrepreneurs in the coalition are hardworking business people that are trying to provide services to Americans every day. The concept of bad faith is a legal one. And that involves an attorney, and that involves time and money. And I can give you examples of what our members have gone through just on its face. This is not about stifling innovation. This is about stopping deceptive practices. So when I hear bad faith, it means that my members will have to go to an attorney, seek counsel. I have many small business members as well as in the coalition. So that does not resolve the issue, especially for the small business people of America.
And Professor, defining bad faith?
Yeah, fortunately, there's a lot of judicial case law applying a bad faith standard. At the time the Federal Circuit was created, which was back in 1982, the lower federal courts for nearly a century had been addressing this question of when may a patent holder be liable for its enforcement conduct, and they had enjoined patent holders from making infringement allegations in bad faith. But the Federal Circuit has largely ignored that long line of decisions, instead demanding that anybody who challenges patent enforcement conduct prove that the infringement allegations were objectively baseless. Historically, the courts treated bad faith as sort of a flexible standard that had both subjective and objective components. So under the standard, you would see courts enjoining or punishing enforcement campaigns, for example, where the patent holder threatened a large number of accused infringers or threatened lawsuits but failed to actually ever file them. But at the same time, I think these cases where enforcement conduct was punished were usually egregious, and they often involved claims that were objectively weak on the merits. So I think a good faith standard, particularly when it's grounded in that pre-Federal Circuit case law, would protect patent holders' ability to provide legitimate notice of their patent rights, but also offer the government some leeway to punish the most deceptive and problematic behavior.
And Ms. Ranieri, on the concept of bad faith?
The Electronic Frontier Foundation, as a digital civil rights and civil liberties organization, is a strong believer in the First Amendment. At the same time, I would like to echo what Professor Galizia said, that I believe the Federal Circuit has narrowly ruled in a way that is inconsistent with precedent and the law, and I believe its ruling about what constitutes bad faith is overly narrow. There is room within the Constitution to regulate bad faith behavior as well as respecting First Amendment rights. I would echo Professor Galizia's statements that the courts are very good at determining what bad faith is, and I think we should leave it to them and also to agencies who are used to seeing bad faith behavior to figure out what exactly the contours of that is.
My time has expired. I thank the panelists for their responses. Recognize Ms. Schakowsky. 5 minutes for questions, please.
Thank you, Mr. Chairman. So states have up to now been leaders in the effort to combat abusive patent trolls. Currently, 18 states, including mine, Illinois, have enacted legislation regulating patent demand letters, and some state attorneys general have initiated legal action against patent trolls under their consumer protection authority. Under both the new patent demand letter laws and general state consumer protection laws, many state attorneys general have certain remedies available to them, including equitable relief, civil penalties, and attorney's fee. The Troll Act that passed out of the subcommittee last Congress included a provision that would preempt the state laws that regulate patent demand letters. So first, Ms. Ranieri, you testified that federal legislation, in fact, should not preempt state laws that address issues those states have encountered with patent trolls. So why is it important, do you think, that we not preempt state laws?
Thank you. That's a good question. One of the most important reasons that this government should not preempt state patent troll demand letter laws is that people who receive these letters often don't know who to turn to, and the first person they often turn to are the state AGs and the state agencies. And they are often the first line of defense for people to protect themselves. The state AGs have the most experience with what their citizens are receiving, and they are in the best position to see new developments in the patent troll demand letters and to see the new deceptive practices as they arise and legislate against that type of activity.
So have we seen any instances where there's been any problem with the fact that state attorneys general have been exercising that authority?
None that I'm aware of.
Okay. Professor, let's establish how your name is actually pronounced. Say it again.
Good, because I was about to apologize to the committee because I feel like this issue has sort of taken over the entire hearing.
No, I think we should apologize. Go ahead.
Guliutsa.
It's a tsa. Okay, Guliutsa. Okay.
Yep.
The benefit of preemption would be to provide a uniform legal standard. In your testimony, though, you raised the question of whether uniformity is in fact an important enough policy goal that it should outweigh the benefits of state laws on demand letters. I'm wondering if you could expand on the benefits, also expand on the benefits of not preempting state laws.
Sure. You know, one of the benefits, as Mr. Ranieri mentioned, obviously, is the enforcement capabilities of dozens of states' attorneys general offices might bring to the table. The other is the accessibility of the state governments or some of these small organizations that might be targeted. And then third, you know, I think this, in terms of forming the substance of a law, I think, you know, what we can see from some of these state statutes are maybe some examples that might be informative to Congress if you're to choose to decide to legislate federally. So allowing these ideas to percolate among the state legislatures, allow the states to try to figure out, you know, how do we draw the line from between the bad actors and the patent holders who are asserting their rights legitimately. I think state legislation can shed a lot of light on those questions.
Thank you. Ms. Ranieri, in addition to the issue of preemption, you testified that Congress should not prohibit or discourage enforcement of the FTC Act by states. Can you expand on why state enforcement in this instance is so critical?
I think it's for the similar reasons that I just mentioned and also that Professor Guliutsa also mentioned. State AGs have resources that the FTC might not have. The FTC might only have the ability to go after the worst actors, but that doesn't mean that there are others that are abusing the system. And state AGs provide a secondary line of defense in order to go after those who are targeting particular citizens in those states.
And last to you as well, the last Congress's Troll Act limited the remedies available to state attorneys general to an injunction and compensatory damages on behalf of recipients who suffered actual harm. Would the limitation of remedies discourage states from enforcing patent demand legislation?
It may, and I think that is a definite concern that this committee should have. Importantly, this sort of Regulating unfair and deceptive practices is usually considered to be an equitable sort of action. Courts are very good at fashioning under equitable remedies the type of remedy that is appropriate given the circumstance. And it may, if absent more punitive consequences to patent hold demand letters, they may just shift their activities, seeing no actual consequence to their bad activities.
Thank you. Clearly, this will be an issue that we'll want to discuss further among our members. So I thank you and I yield back.
Chair thanks the gentlelady. Gentlelady yields back. The chair would like to recognize the attendance of a member who is not a member of the subcommittee, but Mr. Tom Massey from Kentucky, from the Bluegrass State, and a noted and world-famous inventor. We welcome your presence here today. Thank you. The chair would now recognize Mr. Mullen from Oklahoma. 5 minutes for questions, please.
Thank you, Mr. Chairman. And just so I don't mess up your last name, Paul came and introduced himself to me earlier. He's from the great state of Oklahoma. Went to Bishop Kelly in Tulsa, Oklahoma, and I guess your parents still live in Bigsby.
That's correct. So
it's always good to see a friendly face in town. My first question would be for Mr. Malta. We just heard the conversation about our attorney generals, and so I'm going to stay on that focus. My own state of Oklahoma has laws specifically against abusive patent demand letters. I want to make sure that my constituents are also protected from these type of letters. And if our committee drafts legislation prohibiting these types of letters, should attorney generals be able to enforce those laws?
Our members believe that, yes, that they should, and that we're more concerned about the outcome as to the protections, because our members are in all 50 states. So if you're arguing preemption, et cetera, that at least there be some immediate baseline standard that is created, and that if states want to come and they want to make laws that are even more restrictive, by all means, go ahead. But we want something done in the very near term that affects our members in all 50 states.
Next question for Ms. Self. What if Qualcomm was hit from a lawsuit, let's say from Oklahoma's Attorney General, then Vermont's Attorney General, then say Illinois' Attorney General? Should a company be exposed to liability from every state enforcement agency? If not, why not?
Thank you for that question. Sorry, thank you for that question. And before I respond to that specific question, let me just say something about the preemption issue and the way the Troll Act was structured last year, at least. It did permit state attorneys general to bring enforcement actions under the federal framework that was set out in the statute, and it would have, to your question, allowed more than one state attorney general to bring an action, assuming that the Federal Trade Commission had not already brought an action. And we thought that was a balanced approach to the problem. The challenge that we're seeing at the state level with nearly 20 laws that have passed and another dozen or so that are pending is that you are seeing a patchwork, if you will, of demand letter laws that all include different standards, different penalties. Some are very broad in scope. They don't clearly delineate the kind of activity that would fall within the demand letter. 16 out of 18 would include a private cause of action. And, to the point that was made about enterprising lawyers, I think it is inevitable that you will see a cottage industry evolve around harassing inventors under these laws. So the preemption language of the bill is really critical to make sure that you have a nationwide uniform framework that provides consumers, recipients with the guidance they need to understand what is deceptive behavior. And again, I think the bill does a good job of delineating what is deceptive statements in the context of a demand letter as well as required disclosures. But it also puts the millions of small inventors in this country on notice as to what's appropriate or inappropriate. And so as we think about traditional state enforcement under unfair trade practices laws, we have to keep in mind that these are communications involving patent rights. These are rights that are rooted in the Constitution. They are dependent on the ability of the patent owner to exercise their First Amendment rights. And so this is really a very different dynamic than the normal activities that state enforcement authorities focus on. So we think the approach of the Troll Act is really the right approach, and it protects all interests in a balanced way.
Thank you, and I'll try to be quick on this last question for Mr. Malta. The realtors that you represent are exactly the type of small businesses that are near and dear to my heart. Could you please tell us specifically the type of information that needs to be included in a demand letter that would allow businesses that receive them to understand what they're accused of and to what extent they need to take legal action on?
Okay, thank you. Yes, in creating greater transparency, 4 items. Okay. First one, specify the relevant patent claim that's at issue. Very basic. Secondly, detail how a business has allegedly infringed the patent. Thirdly, include a description of the patent troll's investigation of the alleged infringing activity. And fourth, disclose the real parties in interest to the dispute. Because many of these letters come from attorneys and they don't state who the party in interest is that isn't trying to enforce the claim or enforce their patent.
Thank you. I yield back.
Chair thanks the gentleman. Gentleman yields back. The chair now recognizes the gentlelady, Mr. Clark from New York. 5 minutes for questions, please.
I thank you, Mr. Chairman, and I'd like to thank our witnesses for their testimony this morning. In addition to serving on the Energy and Commerce Committee, I also serve on the Small Business Committee in our House, and our small business community lists fear of patent litigation is one of the biggest issues they face. So I'm pleased that we're taking up this issue today. Frequently, patent trolls target end users of patented technologies, such as small local businesses who have simply purchased or used off-the-shelf products like a wireless router or scanner. These small businesses often lack expertise in patent law and have few resources. When faced with the cost of defending even perfectly reasonable behavior, they find it is cheaper just to make a payment to settle the case. Ms. Ranieri, to what extent do patent trolls target the little guys, small businesses, startup, mom and pop establishments, and what are some examples of everyday products that patent trolls are now claiming infringe their intellectual property?
Thank you. The extent of the problem isn't known, but I can tell you, as a legal services lawyer, I receive about 1 call a week. And to be clear, these are the people that have managed to find us. There are so many more people out there that don't realize that they should be contacting people like and organizations like EFF. So unfortunately, the full scope of the problem isn't clear, but to be clear, it is a problem. The type of activity that we've seen is, for example, one of the patent trolls that we are looking at right now has accused people of using maps as infringing their intellectual property. This patent troll has gotten licenses, it appears from litigations that they've filed and settled, which usually in patent litigation, that means a settlement has occurred, has gotten licenses from everybody down the spectrum, from handset carriers to the cell phone companies to the makers of applications, and now they are targeting even smaller parties in the space. We believe that these patent rights have been fully exhausted, but because of the cost of litigation, the cost of figuring out whether those patent rights have been exhausted, these trolls can continue to be able to assert patent infringement with essentially impunity. So the problem is large, and we believe it requires action, and we also believe that it needs the disclosure requirements so we can understand the true scope of its effect on our innovation economy.
Let me ask you then, what options do small businesses or startup companies currently have when they receive a vague, threatening demand letter, and do patent holders other than trolls routinely target end users? Could there be legitimate reasons to send demand letters to end users?
The large number of letters that we've seen targeted at end users are from patent trolls. I've yet to see letters that don't come from patent trolls. They may exist, but I have not yet seen one. And, sorry, what options? Unfortunately, there aren't many right now. The cost of litigation for a small business of under $10 million in revenue, the cost of litigation through trial is over $1 million. When that means that employees might have to be laid off and research and development can't happen, this is the cost to the patent troll, or to the alleged infringer, sorry. And unfortunately, as a lawyer, what ends up happening is that if someone comes to us, oftentimes we can only advise them to settle because it just is not possible, given the current available options, to actually fight back and show that they aren't violating anyone's rights.
Can you take a moment and sort of speak to the cost of patent litigation and the feasibility of a small business mounting an adequate defense?
Sure. So on a whole to our economy, it's estimated to cost in the billions of dollars. And those are often tangible costs. And intangible costs are things such as time and stress taken away and taking people away from growing their business. The options that are currently available to those receiving demand letters, those who are end users who are implementing technology made by others, if they have connections with the companies that make these products that are accused of infringement, sometimes they can get help through the companies. Like in the example that I mentioned before, UPS stepped up to protect its customers, and that was a great thing for UPS to do. Unfortunately, for many of these companies, they don't have the connections to do that. They don't have the resources and the knowledge to know that that's something that they should try to do. And oftentimes, there are no other viable options. Even filing an inter partes review at the Patent Office, which we commend these new procedures and we encourage them, even to get in the door, not even lawyer fees, which as a lawyer, and I'm sure many of you are lawyers, we know are extremely expensive. Filing an inter partes review is over $20,000. That's the salary of a worker. That is money that could go in towards building a business. Many businesses just simply do not have this money.
I thank you, and I yield back. Thank you, Mr. Chairman.
Chair. The gentlelady yields back. Chair, thanks. The gentlelady. The chair recognizes the gentleman from Florida, Mr. Bilirakis. 5 minutes for questions, please.
Thank you, Mr. Chairman. I appreciate it so very much, and I thank the panel for their testimony. Patent demand letters reform is an important part of curbing abusive practices that hurt legitimate businesses, as you know. However, I'm concerned that overly broad definitions of patent assertion entities and other provisions that have been proposed, such as fee shifting and joinder, will limit our nation's research universities and their ability to have patented research discoveries transferred to startup receiving venture funding that can develop and commercialize these early discoveries. The University of South Florida, just outside of my district in Tampa, Florida, is a world leader in university-based patents, licenses, and startup companies, and is a major regional economic hub and job creator in our area. Ms. Renier and Professor Gaglioza, excuse me if I mispronounce, what do you believe is the appropriate balance to ensure that the technology transfer process thrives while simultaneously implementing real reform targeted at bad actors with no intention to commercialize innovations?
Thanks. I think a lot can be done by sort of looking at, so I've talked about the history, a long history of courts prohibiting bad faith assertions of patent infringement. And a lot can be looked at by looking at some of the examples the courts have condemned in the past. They look extraordinarily similar to what we see these bottom-feeding patent trolls doing today, sending out massive amounts of demand letters, targeting the customers of the firms that actually manufacture the allegedly infringing technology, making claims that they couldn't, claims they could not have possibly investigated the merits of. So, I think if you look back at those types of cases, you actually can see there's a very clear line between, what is really so abusive as to be considered in bad faith, and the efforts of, say, an operating entity or legitimate efforts by a company to try to license their patents or resolve a dispute before it goes to court. Those lines have been drawn by courts for over 100 years, and I think they're lines that courts can continue to draw.
Thank you.
I would agree with Professor Galuzia, and I understand your question to be, how do we allow for legitimate letters and still legislate against the bad faith letters? And I think what's important to know is that those who are sending legitimate letters, they include the patent numbers in their letters where possible. They will include why they believe someone is infringing, and they will include information so as to allow the parties to really understand the scope of the claims and why there's a claim of infringement or why the patent is not invalid. This is the activity that bad faith patent demand letters don't include. And so I would agree with Professor Galuzia that there is a long line of cases that see this distinction and make the distinction, and I don't think legitimate patent holders should be concerned about any legislation against bad faith letters.
Thank you. Anyone else on the panel like to respond to that question? Okay, thank you. I'll move on, if that's okay. Ms. Renier and Professor Gogliazzo, what factors do you believe should be prioritized when determining standards for demand letters that would address the abusive patent troll practices while still preserving the legitimate patent holders' ability to negotiate license agreements with potential infringers?
Just very briefly, a couple of factors that I think we've talked about so far. One is the number of letters that have been sent out, right? If a patent holder is sending one letter to one specific company, well, it seems fairly likely that that letter is based on some sort of investigation that gives the patent holder a good faith belief that that recipient is infringing. When you send out, as MPHJ did, 16,000 letters to users of common office scanners, it's extremely unlikely that MPHJ has actually investigated the allegedly infringing conduct. So the number of the letters can be a nice source of indication of whether the investigation has happened, and also the specificity with which the letters both describe the patent claims and also the allegedly infringing technology.
Thank you.
I hesitate to give a complete list of factors, and the reason is this. Oftentimes what we see as when letters are shown to us is that it's not one statement in isolation that's a problem. It's the totality of the letter that makes clear that the patent holder has not done an investigation, is trying to extract money. For example, references to the extreme cost of litigation, and I've seen letters with actual links to tables showing the recipient how much money they can receive. Litigation does cost a lot of money, that's true, but it's the fact that they put these statements in there along with other vaguely threatening language that together makes us recognize a bad faith letter. So I hesitate to say these certain things make a bad faith letter. It's oftentimes when we see it all together that we can tell that this is not being sent for legitimate purposes.
Thank you very much. I yield back, Mr. Chairman. Appreciate that.
Chair, thanks the gentleman. Gentleman yields back. The chair recognizes the gentleman from Massachusetts. Mr. Kennedy, 5 minutes for questions, please.
Thank you, Mr. Chairman. I want to thank the witnesses for testifying today and for your attention to an important topic. Professor Guglielmo, thanks for bringing the Boston weather with you. I wish you left it at home, but nevertheless, appreciate it. I want to flesh out a little bit of a conversation we've had before as well. My First Amendment law, while being a lawyer, is perhaps a little shaky. So there's been, I think, some testimony that's touched already on the Norr-Pennington Doctrine, which touches on immunity of parties who are petitioning the government for certain types of liability. Generally speaking, it's my understanding that this doctrine began in an antitrust space, but has been steadily expanded over the course of case law throughout the years. So, Professor, just starting with you, with regard to the Norr-Pennington Doctrine, I think that there's two open areas here, right? One is, does it apply to patent demand letters, and does it apply in the consumer protection context? And I was hoping you can just start with those, kind of that basic framework.
I have some comments that hopefully are sort of somewhat responsive to it. So, the Norr-Pennington Doctrine, you're correct that it was initially developed by the Supreme Court as an interpretation of the Sherman Act in light of the First Amendment, right? So, what happens in these cases was defendants to lawsuits would turn around and sue the original plaintiffs and say, you're a plaintiff, you've sued me, and you have market power, you're a monopolist, and therefore your lawsuit against me is anti-competitive and violates the Sherman Act. And what the court said was, well, under the Sherman Act, litigation activity is actually not illegal under the antitrust laws. The reason being twofold. One, the Sherman Act was intended to regulate business activity, not litigation activity. And two, to make unlawful the conduct of filing a lawsuit would potentially violate the First Amendment right to petition the government. Right? The main issue that I see in applying that line of cases to these patent demand letters is that a patent demand letter between two private companies is just not a petition to the government. It's a private communication among two private parties. So I think that's one main problem with extending, main problem of constitutional law with extending First Amendment petition clause protection to these letters.
And so, given that the case, though, but you're asking it's between two companies, but you're asking the government to enforce a patent protection action, right? That patent in that context.
But the law can, there are lots of consumer protection laws that are similar, that I think were similar to what this committee is considering. The example that I like to invoke is the Fair Debt Collection Practices Act, right? When an attorney, acting as an attorney, sends a letter that's an act of debt collection, it may even be the filing of a lawsuit, right? Those actions under the Fair Debt Collection Practices Act aren't subject to Noor-Pennington immunity. Courts have largely have upheld the constitutionality of the Fair Debt Collection Practices Act. So I think a similar statute that condemns patent enforcement activity, much like debt collection activity, should be on the same solid constitutional footing.
And then, Ms. Rainieri, could you just build a little bit? You were talking about the totality of the circumstances of the letters and such a moment ago, but in your review of the legal literature, do you believe that the general content of demand letters is protected speech?
So as I mentioned, EFF is a digital civil rights and civil liberties organization, and the First Amendment is very important to us. At the same time, I don't believe that the Noor-Pennington doctrine extends as far as the Federal Circuit would have it, and in fact, this recent Supreme Court decisions, just one last year, the legal underpinnings of the Federal Circuit's decision applying the Noor-Pennington doctrine to the demand letters was recently questioned in another case on a related issue. And I believe there is room within the First Amendment, respecting First Amendment rights, to allow for regulation of demand letters. To be clear, what we think the First Amendment does is it makes sure that legitimate patent holders can send demand letters, but what it doesn't protect is bad faith assertions, false statements that are within the demand letter.
And you think that case law or legislation can be developed that it's going to be sufficiently narrowly tailored that will provide for a definition of good faith that the courts would uphold?
I think what actually could happen is that Congress could leave open the definition of bad faith, and courts themselves will narrowly tailor it to make sure that it is consistent with the First Amendment.
Professor?
I agree, and I think it's very possible that the courts, especially seeing the interest from Congress on this particular issue, would try very hard to interpret any legislation consistent with the First Amendment.
Thank you both. Thank you all. Yield back.
Chair, thanks the gentleman. Chair now recognizes the gentleman from Texas, Mr. Olson. 5 minutes for questions, please.
I thank the chair and welcome to our witnesses. Myself, Mr. Malta, Mr. Neri, and sir, I mean no disrespect, but can I call you Professor G? Is that okay? Because if I try to pronounce your name with my thick Texas tongue, I may be exposing myself to a lawsuit for cruel and unusual punishment. All people here watch on TV, so Professor G's okay? Great. My first question for all the panelists, and start with you, Professor G. As you know, there are 18 states right now that have state laws that fight abusive patent letter demands. My home state of Texas is one of the 32 that doesn't have those such laws. But they're being Austin right now, and this issue is on the table. And so they're in sessions for 140 days every 2 years. So it's a brief window of time here. So put your cowboy hat on, come to Texas. How would you like me to advise the people there what should they do, what should they not do if Texas step out and does some laws fighting abusive demand letters?
Yep. So, I think the concerns we've been talking about the difficulty of sort of fragmentation if different states have different legal standards for demand letters is certainly a valid one, particularly for large, innovative firms. I think one thing that your state might consider is looking to the Vermont statute as an example. It has been sort of the most influential of the statutes. It's been adopted by 13 other states. It sets out very simply that it's unlawful to make a bad faith assertion of patent infringement, and it sets out some factors under which courts may determine whether an assertion is in bad faith or is not. And so I think if Texas were to do that, it would be joining a very large cohort of other states that have adopted similar legislation.
Okay, thank you. Yourself, you comment anything you advise our legislature?
Yes, and in fact, just so you know, we've actually been in conversation with the state legislatures in Texas to talk about this very issue.
Expected. You guys are great. That was expected.
Let me just say that so we do think, again, sort of following the model of the Troll Act, that there is, a version of state legislation that would appropriately balance the interests of potential recipients of these letters and the very large number of small patent holders that could potentially get, unintentionally get caught up in legislation of this type. I think the challenge with some of these state demand letter bills that we've seen, as I said previously, overbreadth in terms of capturing activity that could just be normal commercial communications. And I should say that I, with all due respect, disagree with the professor's analysis of Norr Pennington. I think there's a lot of scholarship and case law that affirms that the First Amendment does extend to pre-litigation communications, particularly when you're talking about the enforcement of a property right. But again, the private cause of action that's included in the Vermont statute and several other statutes is really troubling. And so one of the pieces of advice that we've extended to folks in Texas is do not include a private cause of action. You're going to create far more problems than you are trying to solve by subjecting small inventors to harassment. And again, as with the structure of the Troll Act, to clearly delineate activity that is objectively deceptive, trying to enforce a patent that's expired, claiming you're the owner of a patent when you're not, and limiting affirmative disclosures to the kind of information that small inventors can reasonably disclose. Because it's important to keep in mind that the vast majority of inventors in this country are also small businesses, and they may not have all of the information that they need to know whether, in fact, infringement is occurring or the nature of that infringement, particularly when you're talking about negotiations or discussions with much larger product manufacturers. So finding a balance that protects both the interests of small patent owners as well as small business owners, small end users, I should say, should really be the goal in any state. And again, just to reiterate my previous comments, we believe that the structure of the Troll Act is that right balance. And again, it would permit state attorneys general in Texas and other states to enforce against deceptive activity under that framework.
Thank you. And Mr. Malta, no intention to put you between two different people on different sides of the issue, but you're right there, my friend. How about your comments? What can I take back home?
Comments are get it done.
That's easy.
And if you get it done in the state of Texas, then perhaps that will provide the patchwork that will force the federal government to finally step in and say we need to make sense of this so that people can work under a set of rules and we can get back to business in some of these areas. So.
Okay. And Mr. Neri, your comments on Texas or get her done? Is that you echo those comments?
I would agree, and I would also like to add that although we are in the patent context, and Ms. Self raised the issue of it might be difficult for patent owners to be able to comply with a patchwork of laws. To be clear, states have long had different laws when it comes to consumer protection, and companies have had no problems with complying with all those laws. And we don't think that the patent context needs to change or that, and companies still can comply with all the laws. We think if a patent owner wants to purposely avail himself of sending a letter to a state, they can comply with the laws and look up the laws and make sure that their letter is appropriate.
I'm out of time. Thank you. Yield back.
Gentleman yields back. Chair thanks the gentleman. Chair recognizes the gentleman from California, Mr. Cardenas, for 5 minutes for purposes of questions, please.
Thank you very much, Mr. Chairman, and I appreciate this opportunity to discuss this important issue that really is hampering our economic ability throughout the country. One of the things that the United States has been recognized for, and we should be very proud of, is we're the innovative capital of the world. But when we have people who take opportunity to try to thwart that, that's something that, to me, strikes at the core of our ability to continue to be an economic driver, not only for ourselves as a country, but for the world. Last year, I introduced a bipartisan bill to address patent troll abuse at the International Trade Commission. Patent trolls have been impacting businesses in every forum, and we should do everything that we can to curb their ability to exploit businesses of every size, small and large. Patent trolls' abuse of the complicated patent system can harm our economy and hamper innovation by imposing huge litigation costs on productive companies. I'd like to get a sense of the significance of the problem that faces us here today. Ms. Ranieri, in your testimony, you quoted Seventh Circuit Judge Posner's statement, and I'm paraphrasing. Patent trolls are not trying to protect the market for products they want to produce, but instead lay traps for producers. How does patent troll activity negatively affect the economy and innovation, as far as you're concerned?
So let me give an example. What we see in the Bay Area is a lot of people who are developing new technologies. And for example, apps on a smartphone. These innovators, they want to bring a new product to the market. They're very excited. They come out and they bring it to market, and hopefully it becomes successful. What then happens is later they'll receive a demand letter or a filing of a litigation claiming that they infringe on patent rights. These innovators have not seen these patents before. These are not cases of copying others' ideas. These are cases of innovators who independently created works and brought them to market and tried to grow their business. And once they become successful, become targets of patent trolls. And this is the cost to our economy. It is people who are independently creating, independently innovating, that then get targeted by those who have created nothing and instead wait for someone else to do the hard work of developing products, testing, marketing, things like that. And not only is the financial cost significant, the settlement demands are extreme, but also it takes away time and energy from actually growing the business. Instead, it directs it towards stress, gathering documents, and although this might be good for the lawyers, it is not good for the companies.
So, for example, what you just described, I would imagine, could in fact wreak havoc on a small inventor, a small company, maybe with 5 employees or 10 or 20 employees, that particular product is the reason for their existence as a company. Could that kind of activity actually bring such a company like that to bankruptcy or to actually fold? And when I say fold, that means that 5 or 10 or 20 employees in that scenario now will have to go look for work elsewhere. Have you ever seen that happen?
We have. Actually, there was a case very recently. Someone contacted us, and they were being sued by a patent troll, and the patent was on placing photos from sports events online and allowing someone to search those sports events for their bib number in order to order a picture. And there's actually a patent on that. And it was a small 4-person business, and he was extremely scared that he was going to have to lay off employees in order to fight back. He chose to fight back, but in doing so, he spent a significant amount of resources, and eventually this patent was actually invalidated. But the amount of money and time and stress that took was significant.
Upwards of how much did he spend? I mean, was it only $5,000, $10,000, $50,000 perhaps?
So I don't know his particular case, but having been in private practice, what I saw happen in his case, I would estimate anywhere from $200,000 to $250,000.
Exactly. That's a small business. Very few small businesses can part with those kinds of resources and stay in business. And that is at the core of what the problem is. The problem here is, in my opinion, we have individuals and law firms that are just preying on people without even any regard or concern for the cause and the consequence of what happens. And to lose in such a case or what have you, it appears, in my opinion, that an organization that would bring that upon a small business would probably still flourish and go on. Probably have many irons in the fire, such as the one that you just described, but you have a small business, one after another, who just disappear because of this practice that should not be allowed. Thank you very much, Mr. Chairman. I yield back.
Gentleman yields back. Chair thanks the gentleman very much for his questions. Chair recognizes the gentleman from Illinois, Mr. Kinzinger. 5 minutes for your questions, please.
Thank you, Mr. Chairman, and again to our witnesses, thank you for being here today and spending some time with us. Ms. Self, companies like Qualcomm have large patent portfolios because they have invested a large amount of money in new patents and the creation of new products. and presumably many of Qualcomm's patents can be similar to patents held by other companies. When Qualcomm believes a similar company with a large patent portfolio may be infringing on its patents, how does Qualcomm open communications with that company?
Well, let me just say at the outset that, Qualcomm, we've been in existence for 30 years. Today, we're a large, mature company, as you said, with one of the world's largest wireless communications portfolios. But our roots were as a startup. 7 engineers, 7 academics who had what they believed was a highly effective solution to what was then viewed as a intractable problem in wireless communications, and solving that problem has allowed this mobile ecosystem to grow, and we would not have an app development community or industry without the hard work that engineers at Qualcomm and other inventive companies undertook. So today, our portfolio is very well known. If you have a smart device, a 3G, 4G device, you use Qualcomm technology, and if you are a legitimate player, you come to Qualcomm and seek a license. But that dynamic is entirely different for small inventors in this country. And I just wanted to take issue with the characterization of inventors as creating nothing and all the hard work being done by product manufacturers. Inventors in this country are, I think, responsible for the vast majority of economic growth and success that we've seen over the last 200 years. And so characterizing inventors as doing nothing simply because they don't manufacture a product really does disservice.
I get that, and I'll let you on somebody else's time kind of expand on that. But my question is, if you have a company with a large patent portfolio that you believe is impending potentially on what you guys have, how do you open communications with that company? Candidly, I'm not part of our licensing team, but as a lawyer, I'm assuming that you send a letter, you pick up the phone, you send an email communication, you initiate a conversation about the fact that you believe that the other company's products may be infringing or reading upon some aspect of your portfolio. So again, it's the communication. And Professor, I'm curious as to how private causes of actions have worked in the states. Have they been effective?
So, no. As far as I know, there actually is not yet, these statutes are so new, there actually has not yet been a private cause of action actually asserted under any of the statutes. The claims that we've seen so far challenging these mass enforcement campaigns actually come under sort of pre-existing general consumer protection and deceptive trade practices laws.
Okay, all right. And are there other theories rooted in tort law that would allow businesses or individuals to reclaim money that they lost to a patent troll?
Absolutely. So as I mentioned the example of general consumer protection, deceptive trade practices laws, there are theories of tort law available, tortious interference with business relationships. If a patent troll is targeting your customers, you might be able to assert that claim. You can assert claims of unfair competition under state common law. Under federal law, for example, when Innovatio sent letters to 8,000 users of wireless internet routers, the manufacturer of those routers, Cisco, Netgear, Motorola, actually sued Innovatio under the federal RICO statute, corrupt organization statute. Sorry.
And I have one more question for you. In your testimony, you mentioned Illinois and a couple other states have taken a slightly different tact on dealing with patent trolls. Namely, they focus on specific acts or omissions that violate the statute rather than prohibiting false or bad faith assertions. As I'm sure you're aware, the business community in Illinois appears to be more comfortable with this approach. What lessons should Congress learn from this approach as we try to balance going after patent trolls with protecting legitimate communications between businesses?
Sure. Certainty is important, and I think that sort of pervades a lot of the discussion, both in terms of should the federal government regulate this or should the state government regulate this, and also the question of what should the standard we're judging this under be. And one that provides certainty is important so that, legitimate assertions of infringement are not punished, but deceptive assertions that intentionally target small businesses, as these mass enforcement campaigns do, are punished.
Okay. Mr. Chairman, I'll yield back. Thank you.
Chair thanks the gentleman. Chair recognizes the gentlelady from Indiana, Ms. Brooks. 5 minutes for your questions, please.
Thank you, Mr. Chair. Professor Galiza, I'm worried about the widespread practice of sending abusive demand letters. As we've heard, it's a drain on employers and a drain on jobs. And apparently, according to a University of California Hastings College of Law study, 70% of venture capitalists had portfolio companies that received patent demand letters. It does seem suspicious to see so many startups hit with patent claims, and it's troubling to think, and as we've heard, that startups in particularly may have a good bit of their funding and money going into fighting patent claims right off the bat. Do you have any sense, or have you seen anything that talks about how much money and how many jobs are being impacted in our economy to fight off these types of abusive demand letters?
So quantifying the effect of these demand letters is incredibly difficult because the persons who are targeted with them or the persons who purchase licenses because of them are not very willing to identify themselves or disclose what they've done. The reason being that it just makes them a target for the next round of demand letters.
And Mr. Malta, do you have any sense from those you are representing how many job losses there have been among your members?
So the job loss is direct and indirect. Direct when a company's put out of business, okay? And that is more quantifiable, but it's also indirect. We could provide an example such as JCPenney, who now has a policy of no longer employing or hiring a startup company and getting them the latest technology out of fear of being sued, because lawyers go where the money is. And so they'll go with the startups, and then, of course, they'll go for the deep pockets and some of the major corporations. So that's affecting small businesses in a great way when they're not being hired by larger businesses out of fear that they'll be sued by patent trolls in relation to their work.
Do we have any information as to how many companies have been put out of business? Has there been, and while I recognize that that could be difficult, Ms. Rainieri, anyone know if we have any estimates of how many companies have been put out of business, whether it's startup or larger?
To be frank, we can't figure that out right now. Patent trolls take advantage of the fact that this occurs in the shadows, and that's why we at EFF think it's really important to implement disclosure requirements so we can understand the true scope of the problem and the effect that it's having on our economy.
Thank you. And finally, Ms. Self, certainly I'm concerned about protection of property rights, ensuring that innovators have the confidence that their patent rights are going to be secure. And you've made a great point in your testimony that IP-intensive industries account for more than 1/3 of U.S. GDP and directly or indirectly support over 40 million jobs in this country. If we do move forward, and I appreciate your point on the Troll Act from last Congress, but if we approve legislation, what is the most important thing you think we need to focus on to get it right in order to protect legitimate patent holders' ability to communicate with potential infringers or licensees?
Thank you for that question. It's hard to point to just one piece of this bill that's the most important factor. The framework of the bill, I think, the four factors that I mentioned in my oral statement, the fact that it is limited to bad faith communications, the fact that it clearly delineates categories of deceptive activity as well as required disclosures, but in a way that's balanced and respectful of the rights of patent owners. The preemption issue, again, I think the combination of preemption with the authority of state attorneys general to enforce the law under the federal framework, those components I think are really critical. And I think, again, it's that framework that provides the balance and not just one particular component. So I think all of those components work together to provide an effective solution to what we, I think, all agree is a problem, but without creating unintended problems for patent owners. Because, the other part of this calculus, if you will, is that if you make it so onerous for patent owners to enforce their rights, then they will become the target of abuse by infringers, by opportunistic lawyers who use state laws to harass them. So that's another important focus to keep in mind as we try to chart forward with the right path.
Thank you. Thank you for thoughtful response and for all of your work and all of the input all of you are providing us. Thank you. I yield back.
Gentlelady yields back. Chair now recognizes the gentleman from Kentucky, Mr. Guthrie. 5 minutes for questions, please.
Thank you, Mr. Chairman. Thank the panel for being here. Sorry, I was in another hearing of this same committee in another subcommittee, so I apologize. I may ask questions and y'all sort of repeat a little bit what Ms. Brooks just asked, but I think a lot of us here are just trying to get our hands around this. I think when you talk about the sports, my son played Little League, because I know there was guys in my area go online, you can buy pictures, and I could see where that, in the $250,000 in those stories are out there, they're real, and that's clear. We need to stop that. Then I have my friend Thomas Massey here, who represents northern part of Kentucky, District 4, 3, or I'm 2, so 4 maybe, 4 in Kentucky, who's an inventor. And so when we hear the story like you, Ms. Ranieri, and it's like, well, this is simple, we need to fix this. So that's obviously needs to be fixed. And then you hear people say, well, if people have patents, if they're not using them, that's a good way, like the manufacturer. Well, then Thomas explains in a long dissertation at breakfast one day about how a lot of people who are legitimate patent holders who legitimately invent hold these patents because they don't have the means or they have the ability or they're trying to move forward. And so if you do this, then that kind of reaction to stop patent trolls could stop the small entrepreneurial inventor. And so you have unintended consequences. So I guess what I'm asking, is there any of this expert panel, well, where can we delineate between what, was the old Justice Potter, I know it when I see it, I can't really describe it, but I know it when I see it. And how do you delineate between what's clearly somebody out there patent trolling versus, somebody like Thomas who works in his garage and comes up with, essentially it's what you didn't come up with several patents that, takes him a while to find the resources to move forward. And so the question is the people just out searching, and then you got trolling, and then you have the people, the legitimate small folks. And that's what we're trying to find with the balance, because we want to fix the problem, but we don't have unintended consequences. So I'll kind of open it up to the panel.
Thank you. With an issue like this, there's a starting point, and you're here at the starting point. And that's to stop deceptive practices. Mm-hmm. And we're not stopping innovation. And so you're right, it's that balance. But let's stop deception. And that's why we're suggesting and recommending that these letters have a basic information in it. And basically stated earlier, state the claim, who's the party in interest, etc. And that would be the start to a much greater reform that will probably evolve over time that will deal with the balancing that needs to be done to preserve innovation.
Yeah, let me add, the enforcement efforts I think this committee should focus on are particularly egregious, right? They, for example, are targeting large numbers of end users of relatively commonplace technology, right? MPHJ sends 16,000 letters out alleging infringement of use of a common office scanner. Innovatio sends out 8,000 letters alleging infringement because of the use of common wireless internet routers. Right? So these are egregious. They're sending out large numbers of letters focusing on end users, and also the patents themselves are sort of you might say they're objectively weak. So an example of this is a troll up in the Pacific Northwest called Savannah IP. It sent letters to home builders throughout the Pacific Northwest alleging infringement of a patent on a, quote, moisture removal system to dry lumber during construction. So if you're using a fan to dry your lumber during construction, you may be infringing Savannah IP's patent. There are real questions about whether that patent is valid, and those sorts of assertions are the ones.
Well, I agree with you 100%. So you walk out of that and you're going, boy, this is easy to get behind. Let's get on board. Let's move forward. I like the legislation. Then you have the talk with Thomas and saying, well, these are some unintended consequences that could come from that, and you walk out going, we're really trying to figure out exactly what the right thing to do is, because we all want to solve the problem. I think even people who you're probably hearing oppose the current bill will say, I've heard Thomas say, I recognize there's a problem that needs to be solved. Yep. And so what we're trying to figure out, where is that? Every situation you described where somebody's patenting a fan, we all agree needs to be fixed. Yep. I think most all of us.
I would just encourage you to trust the courts. they can tell the difference between the good actors and the bad actors.
Well, the problem is a lot of people go through court. The problem is the expense of going to court. So, I mean, that's what we're trying to solve. That's one of the problems we're trying to solve is that people are just paying. They're sending out 8,000 letters if 1,000 people pay to not go to court. So just using that as a solution, that's actually part of the problem we're trying to solve.
If you have enforcement by state attorneys general or the federal government, that can help rectify the sort of resource imbalance that you're talking about, I think.
Yeah, but just relying on the courts is what we're trying to solve. That's the problem, the expense of that.
Can I?
I think I'm out of time, so the chairman wants
Chair will allow both Ms. Self and Ms. Ranieri to respond.
Echo part of the comments that the professor made. First of all, the bad faith requirement, I think, is an important dividing line between legitimate communications and communications that are appropriate for FTC enforcement authority. And again, the goal, or at least from our perspective, the goal here is not to expand FTC authority, it's to clarify it. But the pattern or practice component, I think, does help, again, further delineate, because we've seen at the state level proposals, for example, that any patent owner that sends 10 demand letters is automatically subject to enforcement. That's really not an appropriate approach. Pattern or practice connotes widespread communications that meet a standard of deception, and I agree that that standard will evolve through the courts. I think the Troll Act helps as a starting point because it clearly identifies some areas where you do have clear, objectively verifiable deception, as well as some minimal baseline affirmative disclosure requirements. But also the FTC authority is traditionally been limited to consumers, and that means small businesses, nonprofits, as well as individual recipients. I think that's another dividing line that helps with the problem that I think you have rightly laid out for us. If large companies are receiving demand letters, that's a very different dynamic than small mom and pops, and it should be treated differently under the law. So I think all of these various, what I consider to be safeguards, if you will, that are set forward in the Troll Act, I think help solve the problem that you've articulated.
Yes, Ms. Ranieri.
I just wanted to add that EFF is our constituency are the small innovators and inventors. And unfortunately, as Mr. Malta said, this is a starting point, the deceptive letter practices, but our position is until we get better patents issuing out of the patent office, until we stop the flow of patents that should never be issued, we cannot solve this problem, and that's why broader reform is needed. Once patents become once patents that issue out of the patent office can actually be looked at and seen as actual inventions, this will make it much easier and clearer to solve all of these problems.
I think that's the argument Thomas Massey made, but he made it in 30 minutes. You just made it in once. I appreciate that very much.
Gentleman's time has expired. Chair would ask of the ranking member, do you have a follow-up question?
I do not.
Ranking member has no follow-up question. The only thing I was going to ask in follow-up, and Professor and Ms. Ranieri, you all talked about flexibility, but then Ms. Ranieri, you had given us an admonition earlier, don't give us loopholes or we'll drive a truck through them. So how do we achieve that balance between flexibility and loopholes?
That's a good question, and I think that's where the courts and the attorneys general and the FTC and other agencies like the FTC come into play. They can recognize these activities, and as I mentioned, at its base, these laws are meant to target unfair and deceptive trade practices. And these are activities that states have a lot of competency with, in that they see them a lot in different industries. And they can apply the knowledge that they've learned in those industries to this context. Patents are involved, yes, so that changes it slightly. But at the base, the types of deceptive and unfair practices often span many different industries.
Yeah, and I agree. I think the allowing the courts flexibility rather than sort of hamstringing them with a complicated statutory definition of bad faith or a long list of factors of bad faith is very important in allowing courts in a case-by-case basis to try to close those loopholes.
Chair thanks all of our witnesses, and seeing no further members wishing to ask questions, again, thank the witnesses for their participation. Before we conclude, I would like to include the following documents to be submitted for the record by unanimous consent. a letter on behalf of the National Association of Federal Credit Unions, a letter on behalf of the Direct Marketing Association, a joint letter on behalf of the American Bankers Association, the American Insurance Association, the Clearinghouse Payments Company, Credit Unions National Association, Financial Services Roundtable, Independent Community Bankers of America, National Association of Federal Credit Unions, and the National Association of Mutual Insurance Companies. Pursuant to committee rules, I remind members that they have 10 business days to submit additional questions for the record. I ask that witnesses submit their responses within 10 business days upon receipt of the questions. My understanding is a late arrival, a letter from the National Retail Federation, which will make part of the record, and
Without objection.
without objection, so ordered. And then without objection, the subcommittee is adjourned. I thank the witnesses.
Thank you.
Professor Guglielsi.
It's a pleasure.
Thank you. Pleasure.
I forgot to mention, in your statement, you